Hello, and welcome back to Coin Lady channel. You probably already know that Ripple is being sued by more than only the SEC. There is a case that has been going on for nearly 5 years now. And they're making a lot of the same arguments. In reality, though, the technical complexity of the matter is lower. Recent efforts have focused on obtaining class certification to proceed forward with claims that Ripple offered XRP as unregistered securities. Yes, they were able to. They did, which is a pity. I'm afraid this is bad news for Ripple. A lawyer for XRP investors has said that class action certification against the Ripple cryptocurrency is harmful for the company. Nonetheless, there are varying points of view on this, so it's not like everyone agrees that it would be the end of the world. But I'm going to discuss the most recent development, and I've had feedback from 4 lawyers in the XRP community. John Deaton, Jeremy Hogan, Bill Morgan, and Fred Rispoli are all attorneys. But before we go any further, let me make it perfectly obvious that I have zero experience in either law or finance. Please do not take anything I say as professional advice. Furthermore, you should not use what I say as a basis for making any financial decisions. Okay, I'll admit that I'm just a fan who occasionally dabbles with the world of crypto by way of making silly videos for my YouTube channel. Let's do the bare minimum in terms of setting the table. Consider this February 7, 2019 headline as an example. This is from the Crypto Basics. Deaton hopes to use to counter the assertions of Zach and V that XRP is a security. That's the name of the investigation that has been going on for well over 5 years. To get right to the point, the article in question discusses the view and analysis of one James K. Filrun, lawyer for the XRP crowd as well. This is what he said at the time, and I haven't heard from him recently about what's happening. But I feel the need to cover this groundwork. Information first. And on February 6, he wrote the following. Zach and Avi Ripple in California, and John Deaton plans to make a motion to file an amicus brief. The plaintiffs contend that Ripple's unlawfully offered XRP in the form of a security. They are requesting that the court certify a class consisting of everybody who has ever bought, held, or sold XRP and suffered a loss. Those who disagree with the plaintiffs in Zach v. Ripple, 75,890, would be included in the proposed class of all XRP holders. No. Assert that XRP is not a security. People, then, consider this. As far as vulgarity goes, this is the pinnacle of it for me. And I get that this is the way the law works, I'm not naive. But you can't dispute that it has a ridiculous ring to it. You're referring to the community of XRP investors, which is nearly unanimously, if not unanimously, opposed to the idea that XRP is a security issued by Ripple. We disagree with this idea by a huge margin. But what he's pointing out here is that, at least in the United States, we might all be included in this class if it were certified by a judge. What a moronic thing to say. But the law doesn't function like that. This is how the law operates. The attorney filing goes on to clarify that the proposed class is not limited to purchases made directly by Ripple, but rather covers all sales of XRP, including secondary sales and foreign sales in jurisdictions where XRP is not considered a security. John Deaton will contend that the court ought not certify the class because of these differences of opinion. Also, only a minority of XRP holders have raised concerns that the token is actually an unregulated investment, despite the claims of a large minority of XRP holders globally. John Deaton will argue that the plaintiffs in Zach enough do not have a sufficient number of supporters to fairly represent others who disagree with them, particularly those who possess XRP in jurisdictions where it is not deemed a security. Also, I'm going to tweet this out. The date was February 6th. Because I found it to be quite amusing. I wrote about it when it happened. Attorney Fred Rispoli chimed in on the thread with the following. If you're familiar with class action lawsuits, you know that the effort to have the case certified as a class action is the most crucial one. Coming in as you do is a big kick in the balls for plaintiffs' counsel, so good move, John. I agree with John that the importance of the ball kicking, it is indisputable. That is just so awesome. Very persuasive argument, Ms. Rizzoli. In a word, I adore it. Even so, it was disappointing to learn the news today, but in a technical sense, this did happen. The 30th of June, probably. The news first emerged 2 days ago, but it wasn't until yesterday that it really needed to be extensively disseminated. This, as you can see, is a brand new, up-to-the-minute piece. The spread of information, then, requires time. However, before we get too far, I'd like to give the opinions of a few of the attorneys who are active in the XRP community. However, Bloomberg Law has published an article titled Ripple Labs Crypto Investors Get Class Status in Security Suit. In a crypto securities action filed against Ripple Labs by token holders who lost money, the token holders were certified as a separate class. CEO Bradley Garland plans to fight the certification with his company's XRP subsidiary. However, the 4 benchmarks were all met by the group. On June 30th of this year, U.S. District Judge Phyllis J. Hamilton of the Northern District of California issued the following ruling. So, just to be extra, I'll pause it once more. Clear. Only the class certification is included here. This is not a judgment in favor of the plaintiff because, we haven't reached a resolution. The question is whether or not Ripple broke the law. Just recently, a class certification has been implemented. Now we move forward with things. At any rate, calm has persisted. The lawsuit claims that the defendants violated federal and state securities laws by selling XRP and other unregistered securities to individual investors for hundreds of millions of dollars. According to the evidence presented in court, the plaintiffs successfully demonstrated that the class issues will take precedence over the individual ones. Ripple claimed that the plaintiffs did not show that they would sufficiently defend the interests of the class, and the judge agreed. Bradley Sustek, the named plaintiff, made secondary market purchases, making his claims vulnerable to unique defenses, and many proposed members didn't agree with the premise of the complaint. You buy XRP from someone who isn't Ripple, and then you blame Ripple for problems. This is an interesting thought. As always, there are good reasons for this, people. Here then is the response of attorney John Dean to the issue. If anything, the plaintiffs' counsel should be praying the SEC loses and Ripple wins because this class action is the least of their concerns. If the SEC were to win the entire case, it would be responsible for collecting the settlement and establishing a fund to compensate XRP holders. Judge is likely to agree with Judge if Ripple prevails. It's humorous to consider that if the SEC prevails, the plaintiff in the Zach Enough case will lose. And I'll add this, too, no matter how ridiculous it sounds. And XRP owners at the time period mentioned, which was in 2017 at some point. Until roughly June 30th, 2023. I wouldn't take part in something like that even if it meant financial gain for me in the future, since I find the whole thing morally repugnant. This is the Zacon type of guy I'm thinking of, though SaltStack is also a possibility. However, or perhaps there's another guy, Ryan Coffey was at least one of them, if not more than one, who held XRP for around 2 weeks around the time of the all-time high before selling at a loss. It's just how fragile stuff is, that's all. Can you ever fathom, can you honestly say that you are putting your faith in Ripples to do something that may theoretically affect the price of XRP and that you are giving them 2 weeks to do it? The whole thing is just the most ridiculous bullshit ever. In any case, I'm only saying that despite the prospective financial reward, I would never take part in this possibility. No way, no how. It's repulsive to me. Someone cut the list of names down. John, how does all this affect us UK holders? XRP asked as a reply to attorney DT. What if there was payment of some sort? How do they tell each other apart? Do routine class certifications, as penned by attorney Deaton, occur? The plaintiffs sought to represent all UK holders of XRP in a global class action. But the Financial Conduct Authority in the United Kingdom has ruled that XRP is not a security. The same holds true in Japan, Singapore, the United Arab Emirates, etc. Investors from the US alone. However, this issue is extremely straightforward in comparison to the SEC case. They were hoping for an international seal of approval, but this one is valid only in the USA. It's hard for me to see that this would go much further than this, especially with the thought of the winning Ripple having to pay. Here is the reaction from Hogan, an attorney. When a judge grants certification of a class, it simply indicates that he or she believes there will be a sufficient number of plaintiffs and that the claims should be treated as a whole. In this case, the answer is so obvious. But that won't change the outcome. CCK at all. However, I am interested in seeing how the SEC case plays into the class action. Okay, and let me add this. One of the judge's rationales, I believe, is that the audience for this channel includes not only folks like me but also, realistically, all of you listening. If you share our view that XRP is not a securities issued by Ripple or anything like, read on. The judges seem to have the attitude that, hey, no one is making you accept payment or do anything like that. That's the line of reasoning, I guess. It helps to rationalize this. That class wants to speak for XRP holders like me, and you makes the whole thing appear ridiculous. They are not advocating for us. Absolutely. Given res judicata, in fact, I had to Google this one, that lawyer Bill Morgan wrote to that lawyer Hogan. Though I was familiar with the term, I had never taken the time to memorize it. I immediately turned to Google. Res judicata is defined as an issue that has been decided by a court of law and cannot be revisited by the same parties in the same court. So, according to Morgan's legal advice, the only people who may rely on residential judicata on substantive matters are the same people who are involved in both proceedings. Even if we discount the persuading power of tors as the deciding factor, the divergent conclusions reached on the question of whether Ripple sold or offered shares are intriguing. That would be both fascinating and incredibly stupid. Imagine, though, that two judges reach opposite conclusions about whether or not Ripple was responsible for the act in question. Wow, this is some crazy place to live. Fred Rispoli, an attorney, was also present. And he put these words down on paper. The order and story are behind a paywall, so I can't read them, but this looks awful for Ripple. Certification of a group is bad for business. The same tactic may work here, though, seeing as how it has lasted this long with SEC. The next stage is a summary judgment in this case. This explains why the SEC case piece exists. More importantly, I need to learn more about the implications of a ruling that XRP is a security in this Oakland case, notwithstanding a previous ruling that it is not a security in New York. Mark Fagel, attorney. Now that we know what res judicata is and that attorney Fagel is a former SEC attorney, we can move on with confidence. Collateral estoppel was also discussed. I had forgotten what that one was, too. Because of Google and the internet, I have access to an incredible amount of information. I did some research, and the results appear on your screen. The doctrine of collateral estoppel states that a previously contested subject cannot be litigated again. Honestly, it sounds like something close to a res judicata. In addition, they stated that this precludes bringing the same criminal or civil action before the court twice. Solicitor Fago chimed up, yeah, too long since I took Civ Pro. Even without binding legal impact, I expected that class plaintiffs would argue no collateral estoppel if Ripple prevailed against the SEC. It probably played a role in the decision made by the California court. I expect it to be the case regardless of anything else transpires in the crypto space, so yeah. However, it's important to note that the rulings of subordinate courts and other administrative bodies are not binding on higher courts. In legal terms, it does not establish a standard. Even so, it may still convince. This will still have an impact on the decisions of other judges. So if I told you that it would be good enough if Ripple won the case against the SEC, you'd believe me. In any case, there we are. This whole thing is a load of rubbish. But this is where I'll stop. No, I don't give out financial advice. Nothing I say or write should be used as justification for the purchase or sale of anything. Please like and subscribe my channel. See you later, bye.